Right then, so good evening everyone and welcome to tonight's webinar. It's been a while since I've done one of these, and so we'll just dive straight into it. As per my preamble before we got started, this is in webinar format, so questions at the end please, and by all means put them in the chat. I'll make sure there's plenty of time for questions at the back end of proceedings, but there's plenty to go through, so we will go through it as per slides. So as with any good webinar presentation, I've got to introduce myself, and here I am. So now into my 21st year of being a town planner. I am chartered. That means I've got an obscene number of initials after my name, and that only got worse last year when I added FRGS, or Fellow of the Royal Geographical Society, to that as well. I'm an accredited CPD trainer. I'm an active planning consultant. 45 is a bit under what I've currently got working on at the moment. We teach planning through our Victory Plan, and I'm published in YPN. I'm now a regular contributor, providing an article once a quarter, and the next one is on the death of serviced accommodations free ride inside of the planning system. I hope you'll read that and enjoy it. Right. This is us, Town Planning Expert. We were established in 2012. We're a general needs planning consultancy. We cover England and Wales. We're a chartered town planning practice with 3 chartered planners and 2 planning assistants. We're an accredited CPD training organisation. We're an ethical developer. We've helped over 1,000 businesses with their development proposals, and we have over an 80% success rate on planning matters. It's part of a family of companies which involves our main planning consultancy, Tricerno, which is our development arm, and TPX EDU, which is our education arm. But it's Town Planning Expert tonight that brings you this webinar. Tonight, this is going to be a very, very different way of me doing things. What those of you who might have seen me speak before might be used to is me waxing lyrical about permitted development. But planning is not just about what you can get under PD. Oh no, it's not. You'll always get a better and less compromised scheme through a planning permission. And this presentation is a reflection of my 20+ years in service in order to show you how to get planning permission and to play the game as it is today. My experiences relate to England and Wales. I really regret dealing with Wales on occasion, but I don't regret dealing with England. I really enjoy working inside of the English system. My ability to work in Wales is going to get curtailed even further by changes to the Welsh planning system, which deviate it from England quite substantially. So best to think of me as an English town planner. I'm going to give my normal list of fair warnings now. Again, for those of you who know me, you know what I'm about to say. This presentation is based on actual examples and real world experience. None of what I'm about to give you tonight is theoretical. I'm going to try and slow things down. This is in webinar mode. This is being recorded, and so you should be able to watch it back on the YouTube channel. That's the Anti-Guru, at your heart's content, because that's where it's going to go after tonight. I can't squeeze everything I've done into the time we have together. We've got about an hour together tonight. I just can't squeeze it in. And so these are ideas. These are examples of where it has worked. And I'm a big fan of those sweary words. Oh God, I love that, the way of saying that. That was borrowed from an American lawyer when they were doing the coverage of the Depp versus Heard case. I'm a big fan of those sweary words, especially when our dogs in the background decide they want to make their presence felt. And so bear that in mind. We are after the watershed. This is adult viewing only. So bear all that in mind. As I said, we do teach the victory plan, and victory looks like this. It is a mnemonic that stands for V for verify, I for intelligence, C for compare, T for teams, O for options, R for reality, and Y is for you. If you want more information, there's plenty on the website. I'm not going to say any more about it. Let's get started. Planning is a game of strategy. It's always really been a game of strategy, a game of moves and counter moves in order to get you where you want to be. Now, sometimes you might have to make multiple moves inside the planning game to get an end result. Sometimes you can just do it in one, but it is ultimately a game of strategy. How you set up that application or that sequence of applications is as important as the outcome itself. Half of the time, as planning consultants, we're thinking 3, 4, 5, 6, 7 steps ahead of the planning officer. I've got a case right now where we've had to think 5 steps ahead of the planning officer in order to try and get our client where they need to be now, because we need to close down the options available for that planning officer when they get the application in front of them. That's as important as the win, and ultimately part of the game today. It's a planning process. I love this quote. I've used it so many times and I'll continue to use it day in and day out. How many times have I told you the right tool for the right job? I cannot roll my eyes properly. Nowhere near as well as James Doohan could, who played Montgomery Scott on Star Trek. And yes, all planners are turbo nerds. Planners are tools. Architects are tools. Estate agents are most definitely tools. You use us for the individual discipline that we're really, really good at. Planners are there to manage the planning process. But let's be honest with each other. When you're looking at a site, when you're honestly, truthfully looking at a site for the first time, what's the first thing you do? What's the first thing you look at? Now, I don't know about you, but the first thing I look at is price. I'm always there searching low to high. It may be the Scottish/Irish in me, but I am definitely mean when it comes to spending my money. The offer price, however, is screaming at you. It is absolutely bellowing at you. What is going on? Sometimes this price is too good to be true and betrays what's actually going on. Sometimes you see on an auction a teaser price on a ridiculously low teaser rate. That's to get you in the game, to get you in the room. Here's a couple of examples I found when I had a look in Norfolk. Classic examples of these teaser rates in auction to get you in play. Here we have for £3,000 a wonderful piece of land that is guided, that appears to be part of the front forecourt of people's homes. This, believe it or not, is land for sale, and when you click into it, says may be suitable for development subject to planning permission. I can tell you there's no way you could get planning permission on a piece of land, A, that small, and B, that constrained. But someone will buy it at £3,000 or worse, more. There's another piece of land here, 4,500, a triangular sliver between a highway verge and a main road. This is being sold unconditional online auction. Again, plan for sale, may be a development opportunity subject to planning. The price is screaming. Now, the lower the price, the greater that planning risk. Here are some howlers that were presented to us off the back of an auction. Now, all of these are real. All of these are absolutely real. We've seen £120,000 paid at an auction, and this person paid in full. They didn't pay the deposit, they paid in full. It was originally guided at 60. On the south coast for a piece of land that had more planning constraints on it than anything I've seen in my career. And that was bought on the back of an architect's plan that showed 20 houses. It was just a viability plan. It went to auction. That's how it worked. Then we saw £105,000 spent, guided at 50, on a designated park. Really a park with slides and swings and a trampoline and all of that good stuff that you would expect to see inside of a park. And then finally, £1,000, which went for guide on a piece of highway verge that was 100 metres long and 1 metre wide. Moral of the story is that auctions in themselves are dangerous hunting ground for those who are not willing to look past the price. Look at the price. It is the first and most important piece of evidence that you have on what is going on with that piece of land. Planning ultimately is a rules-based system. It's based on a set of very well understood rules. Here's one of my favorite quotes. Learn the rules like a pro so you can break them like an artist. Pablo Picasso said that. Absolutely true. Learn the rules like a pro so you can break them like an artist. Ultimately, learn the rules better than the planning officer at council knows themselves, so you can break them like that artist. Here's my version. In order to play the planning game, you need to learn the rules. In order to play the game well, you need to know when to break them, especially when that ref is not looking. Especially when the ref is not looking. Ultimately, there is a rule book. Planners are not allowed to make it up as they go along, even though it may feel that they're doing that from time to time. They're absolutely following a very described set of rules, and all planning decisions operate within that rule book. They either come out of the National Planning Policy Framework, which is about to be updated, the county or structure plan, the core strategy or local plan. And these take a top-down approach to planning. They're all accessible and all available in the public domain. This is more important today to understand than ever before because of what is happening within our planning system right now. Planning is getting harder. Let's be brutally honest with you. Planning is getting harder as older and more seasoned professionals leave and younger and greener professionals join. Those younger and greener professionals are taught from day one that there is a rule book and you need to make sure your planning application complies with every rule in the book. So even a minor thing gets a refusal. The Levelling Up and Regeneration Bill 2020 makes this harder, placing even heavier weight on the primacy of a new National Development Management Plan, inserting Section 38ZA within the Planning and Compulsory Purchase Act. Let's try not to stumble over my words tonight, which provides for a national development management policy to take primacy over everything else. That is a core part of the government's reforms. It aims to restore development management back to a more 1950s binary system, take out some subjectivity and replace it with the binary. Thus, knowing the rules like a pro becomes as important as being able to assess whether or not something's viable. Planning compliance is therefore key to easier planning wins. We have some wonderful top-down rules in the book right now. Here is para 149. 149 is our rule book, our set of exemptions to the general principle that development in the Greenbelt is wholly unacceptable. So it is given that development in the Greenbelt is just a no. And that's not just development, it's all development. Now, that is unless you can meet one of the 7 clear exemptions inside of para 149. You only need to find one. It's not magic. It's just using the rules like a pro. I've got a couple of examples to show you where we did that. You can find whether or not you're in a greenbelt simply by looking. There are really no excuses. Here is the layer from Nimbus that tells us where the greenbelt is. There it is. Lovely, lovely. We can see exactly where the greenbelt is. Anything that's not greenbelt, let's take Brentwood here, is not inside the greenbelt. Anything that is green is inside the greenbelt. The moment you cross that line into the green, the rule book changes from development is unacceptable to development is acceptable and vice versa. Cross into the green, development is automatically unacceptable unless you can find one of those 7 reasons. Couple of examples. Here's a permission in principle that was granted for the demolition of existing buildings at French's Farm up in Brentwood. This benefited from para 149G of the MPPF, allowing for that redevelopment inside of the Metropolitan Green Belt. Redevelopment of previously developed land is acceptable in the Green Belt. We then applied for and got a technical details consent, which is the other side of a permission in principle for 8 dwellings. That took some doing because the council had a few other things they could add on to it. But importantly, use the rule. 149G. Development was previously considered unacceptable. It is now acceptable because it benefits from an exemption. Here is a little 3D showing you what will go on that site when it is built out in broad massing terms. Pretty good. Here's another example, Hedley Hall Farm and Gateshead. Planning permission was granted for a new house within the Greenbelt, following the demolition of existing barn and stables. The barn was here, the stables were here. This also benefited from 149G of the MPPF, allowing for the redevelopment in the Greenbelt. A U-shaped building has gone back on this over 2 stories, one of which is in a sunken ground floor that has spectacular views over the Gateshead countryside. 149G, absolutely a friend and absolutely using the rules like a pro. Now, it's not just development in the Greenbelt that has a rule book, everything has. Let's take para 120. Para 120 C, D and E tell us that the government wants, absolutely wants us to deal with previously developed land inside of our towns. They absolutely want you to do it. In fact, they absolutely want you to do it. It's a core of the government's policy towards planning in the future. So, Rushden Police Station. This is previously developed land in a village. And shall we say this absolutely, I'm trying to find words, but let's go with delightful example of 1950s brutalist architecture. Didn't really fit with the aesthetic of the town of Rushden in Northamptonshire. It came with 2 police houses. Police houses are effectively barracks for police officers that aren't on duty. And this delightful snail-shaped thing that was in the middle of the site, surrounded by car park. We managed to achieve planning permission under 120 for the conversion of 2 police houses. So the 2 houses that you see here into 2 family homes. That was relatively straightforward. Houses to houses, it's just a change in occupier. Nothing wrong with that, nothing negative in the rule book either. We then also managed to get planning permission for the demolition of this building to form 5 family homes. And we are going to be applying for planning permission for a final house, house 6 at the back. That was after we won an appeal. I say won, we got it on the result we wanted, which is the council attempted to argue that noise from a heritage railway line with no greater than 15 trains a year was so harmful that it warranted refusal. The rule book is very clear on that point. The rule book is incredibly clear on noise. The council were overstating by a substantial margin. Because they were overstating, the inspector ruled that the council had broken the rules and were overstating. They discounted that objection on grounds that there was no significant noise, using the rules like a pro in order to break them like an artist. Sometimes when you are dealing with planning matters, one must take stepping stones. What are stepping stones? Well, the whole point of the stepping stone approach is to make multiple moves. You can't just go to checkmate and expect to win the game in one move. Equally, you can't, as a goalkeeper, bury your laces in a ball and expect every time to beat the goalkeeper at the other end of a pitch some 96 yards away. That's not going to happen daily either. So sometimes you have to make multiple moves. The whole point of making these multiple moves is to undermine objections. The whole point is to take these multiple moves and use them to usurp some or all of what the planning officer might say. Couple of examples. So here we have an HMO, 12 Vane Terrace. The client originally wanted to get an 8-bedroom HMO, right? Very simple, with some external alterations. The problem is they applied for it all in one go, and that was refused because it was too much. And in reality, the jump from a 3-bed house to 8 people was too much, and the alterations were too much for the conservation officer. Sadly for that conservation officer, all of the external alterations were permitted development. If you apply for them, the council is allowed to refuse them. If you do it a different way and do them as PD, the council can't say boo to a goose, even inside a conservation area. And that's exactly what happened here. So all of the external stuff that the architect had previously asked for, that was all PD. So was the change of use to a 6-bedroom HMO. That was PD too. So that's what happened. Permitted development for externals, PD to change the use. We're now into an HMO. The final change of use, 6-person to 8-person HMO, overcame the previous reasons for refusal to such a degree that the council tried to invent new ones. That went down very poorly with Mr. Inspector, and the inspectorate allowed the appeal against the council's refusal for 8 persons, citing that there was no demonstrable harm that the council could identify going from 6 to 8. There was no demonstrable harm. 125 Laburnum Grove, same broad thing, different process. The client in this case wants to get to a 7-bedroom HMO, but the property is inside an Article 4 area. I cannot just jump into HMO without planning permission. I have to go then through the gears. We can still apply a stepping stone approach. All of the external alterations that were dealt with on this property, the rear extension, the windows to the side, the roof, that was all permitted development. That could just happen. That enabled us to get it into a 7-bedroom house without planning permission. 7-bedroom house, family home. The change of use to a 7-person HMO is the thing that needs planning permission. But what the council is effectively assessing is the difference between a family living there, of which there is no effective limit, upper limit on number, and a 7-person house, when there are 7 bedrooms that all comply with policy, and there's the right amenity space. And in reality, all the harm's happened. What you effectively then do is undermine anything the council would say about over intensification, and you're purely dealing with the brutal HMO policy, which is binary. You either can or you can't have an HMO here. This was approved without the need of it going much further than a planning committee, only because the planning committee has quite a vicious attitude towards HMOs. And in reality, this planning committee cited that this was exactly the type of HMO they wanted to see. Manna from heaven for my client. Stepping stones, taking things step by step. Now, it wouldn't be me without talking a little bit about PD. It's great for a stepping stone approach. You can grow houses, as I've discussed on that previous 2 examples, and that's going to get you something interesting. You've also got prior approval available to you as part of a stepping stone agenda. And prior approval has been expanded to include more sui generis uses, more retail, business and commercial uses to dwellings, etc., etc., etc. You've also got the construction of new dwellings to consider as well. And don't forget, these permitted development rights are fallbacks that rely heavily on, or that can utilise heavily, Mansell versus Tunbridge and Malling, which is the present fallback case law. Mansell is 2016-2017 in the High Court and the Court of Appeal, respectively. When thinking about new development, one thing is fundamentally clear. The High Street is the new development hunting ground. Now, I've been saying this for years, and finally government has caught up, and the High Street has become their key focus. Every change that we saw to permitted development and prior approval in 2020 and 2021 was firmly focused on the High Street. The High Street got more allowances, more rights, more everything than anywhere else, and I think is prime development hunting ground in the future. How many times have you noticed a vacant upper above a charity shop, say, or a hot food takeaway or a restaurant? It's just not being used. It's not being used because people think you wouldn't want to live above them. Let's use them. Couple of examples. Class G is now a prior approval right, but when it wasn't, we were able to do something like this, which is 31 High Street in Bromsgrove. This is a grade 2 listed building and within a conservation area and in a high street location, and it has indeed a certificate of lawfulness on it to convert the upper 2 floors into 2 flats. Class G retains its ability to go to HMO after the effect, and so lo and behold, we then applied for permission through a listed building consent, because you need a listed building consent still, to convert the upper into 1 flat as 1 big HMO. Our client there was very happy with the outcome. Class MA is fabulous. This is one of my recent wins, 46 High Street in Thatcham, again within a high street and a conservation area. And this was a prior approval granted for the change of use of the upper floors to form 5 dwellings. This one was interesting, primarily for the lessons learned. The prior approval went through. Our client was incredibly nervous about the prior approval process. They'd been burned in planning in the past. But what the council really were heavily set on was vacancy. We had to prove that Newbury Building Society had vacated the upper floor. And we had to prove that absolutely. They were not happy with just us saying it's vacant. The reason for that is Newbury had it vacant for so long that it was cheaper for them to pay business rates on it, and the council were using the business rates record to determine vacancy. If they'd gone for the penalty business rate of 150%, why would they? Then it would have been easy. It was made difficult because they'd actually decided to pay business rates, so it looked like someone was occupying. It wasn't, they hadn't, but that's what we had to prove. Everything else kind of went through nice and straightforwardly, really. The conservation officer had fun with this because it's in a conservation officer, and they got very het up by the fact that they were prohibited from talking about it. They were prohibited because we weren't touching the ground floor. But that's why ultimately we utilize a stepping stone approach sometimes. The other part of this stepping stone was to change the windows in order to improve their acoustic efficiency. That was so that noise from the high street was less of an issue. Scouting your council. It is most definitely possible to scout your council and to understand what kind of mentality they have in terms of planning applications. It's highly recommended, even if you spend a little bit of time, which you will never get back, watching the planning committee ahead of time. It's good intelligence gathering for you. They're all held in the public domain and fully transparent. The whole point is to understand what they like and, importantly, what they habitually don't. What we're trying to reveal is decision-making behaviour. It's part of the personality of a planning authority where they consistently deal with certain applications. For example, a few years ago, when I was working at Portsmouth, we had an absolute hatred in that council for dormer windows. Absolute hatred, until such time as permitted development got changed, and then that hatred kind of went away. But until such time, they were very good at defending dormer window applications. Here's property data's layer, and we can reveal some of the planning applications that have gone on in a certain area. This is around our offices, by utilizing property data's applications layer. Nimbus and Land Insight all have a similar layer. So again, no excuses really. It's more a case of doing a bit of homework, a little bit of due diligence on what is going on, in particular in that surrounding area. Where you see those numbers, those are multiple applications that if you zoom in, you'll find multiples. You can also do it the old-fashioned and free way. You can do a bit of history searching. History searching reveals the planning personality of the individual council. In this case, a history search of HMOs in Portsmouth gave us 713 hits, 713 identified ways of either doing it or not doing it. Repeat the mistakes. Do not repeat the mistakes of the past. Repeat the positives that have occurred instead. Many lessons learned in those 713. If we do a similar search for conversions and we go for all permissions within a year framework, I went 19 to 20, we can identify that only one person, only one applicant got it right. Many applications failed, only one applicant got it right. And so repeat the lessons learned and do not repeat the mistakes of the past. All we're doing is scouting ahead in order to make sure we know how that council is likely to behave. Recycling. There are three principles in planning navigation: where the property has been, where it is now, and where it is going to. Where it's been, where it is now, and where it's going to. Who's touched it before you? What's going on with it right now? And where do you want to take it? It's really important to understand. Now, I want to make absolutely clear, there's no such thing as a bad decision. There's only a decision. Our development management procedures order for 2015 states clearly that if they're going to refuse you, they need to tell you exactly why. Those reasons must be clear and precise, and they must specify all the policies in a development plan that are relevant to that decision, and they become a material consideration, positive or negative, after the effect. Couple of examples then. This is the Washington Public House in Barrow. This is an early application I did. I did say it was 21 plus years. I mean, it is a long career. The client wanted to get to a 31-bedroom HMO. They'd already had planning permission granted for 26, and that was on the basis of no objection from the Environment Agency. Once that had been granted, it could be recycled. We could enhance it by a small amount. It's difficult to enhance it by a big amount, but enhancing it by a small amount by making efficiencies is acceptable. Now, the Environment Agency tried to refuse it, and they tried to have it refused based on flood risk. But we had to remind them that that ship had sailed, pardon the pun. They had lost their opportunity to object to it because they hadn't objected to it previously. They weren't allowed to reopen the wound once it had been sutured closed. On the other side of the same site, the client wanted to get 4 houses within the pub garden, and the sole reason for refusal used by the council related to flood risk sequential test. Everything else, design, amenity impact, car parking, bike storage, bin storage, 4 houses, loss of the pub garden, that was all considered acceptable. We did the sequential test and got planning permission granted for 4 5-bedroom houses. And then because we got a sequential test passed, we were then also able to get planning permission for 4 3-bedroom houses, because 5 down to 3 is preferable. Recycling that old refusal enabled us to get the consent that we needed and wanted. If you're in absolute doubt, and I do apologise for the dogs barking in the background, I hope you can hear me over them. If in absolute doubt, pre-app it. Pre-application has had a very bad rap in the last few years, and I said most of it. But in 2019, pre-app became a material consideration in the planning practice guidance. And then in 2021, its importance was put directly into the NPPF at powers 39, 40 and 41. And this gets further enhanced within NPPF 5, of which we've seen the latest consultation on, with further reinforcements to the pre-app process saying, look, for difficult sites, this really should be part and parcel of what people do. The reason why I said pre-app was bad was because it didn't have legal weight. It now has legal weight. It is a material consideration in the determination of a planning application. Raglan Gatehouse, one of our own, and this is indeed one of our own developments. This was a flip in the end, sold to a local developer in Plymouth, because let's be brutally honest, Plymouth is 4 hours away from home, and I didn't really want to be driving down there every week. Is a classic example of this. This would not have happened without the pre-app involvement we had with the council. Absolutely would not have happened. We dealt with it in pre-app because we needed to warm the council up to the idea. We needed them on board. This is a grade 2 listed building, and we wanted to put a new roof on it. We wanted to sort it out. We had to have them in the game. So we got planning permission for the construction of a new 3rd floor to form 4 duplex apartments, the erection of 4 townhouses on the street, and associated parking, landscaping and cycle storage. That, we hope, will now be built out by the developers that bought it from us in Plymouth. Here's a photo montage of what the gatehouse should look like when all is said and done. Maybe with a slightly different colour treatment on that roof, because I know what's been agreed is a grey to match the wonderful granite and limestone facade of that absolutely spectacular building. Not possible without the pre-app, and it was the pre-app that made that application happen. Finally, you can avoid the planners altogether. Very prominent in the news right now is Messer Clarkson, especially after the release of his latest series. Do things that don't need planning permission. Just absolutely make sure you get it right. And sadly, I have to report that Clarkson's farm suffered an enforcement notice against that wonderful little restaurant on grounds that the council believed it breached planning control. Clarkson had gone too far. Use something that's not development, just make sure you get it right. Now, for our not development category, today we've got the wonderful excuse of the use classes order, especially Part E, which got expanded very silently in September 2020 to include so many uses and exclude so many changes of use from the need to get planning permission. This also means that you don't need planning permission to go from an office to a day nursery, or a day nursery to a gym, or for other indoor sport recreation to a clinic, or for a clinic to a shop. They're all now not development. I'm having a wonderful little argument with Decorum Council right now on whether or not they can control the change of use of a shop to offices, and whether or not they should include it as part of a description of development. Our argument is, of course, no, it's not development. Couple of examples then. 27 Tower Place in Kings Lynn. This is in a conservation area surrounded by a listed building within a town centre. Client wanted to change the use of the ground floor to from a Class E shop to offices. They needed to do that to move the first floor occupiers down, because they then wanted to convert the uppers into flats, and they needed somewhere for the first floor offices to go. That happened, and we got that prior approval through, and then a further application went in and has been approved. This saw the subdivision of the ground floor from an E shop to form 3 or 4 shop units. That was not development requiring planning permission, and that was done as part of adding another floor to this building as well. The important thing here is that the change of use of that ground floor and the subdivision of that ground floor don't require planning permission. They're not development. And the fact that they're not development means that we can just go ahead and do it. They're beyond the scope of control given in the Planning Act. One final example at appeal right now, because the council don't believe this is a creche, is an existing creche where policy resists the loss of creches. The council had even refused a previous application on this site, saying it would result in the loss of a creche. The building is therefore a creche, and we want to take it to Class E offices. This would directly overcome the policy blockage. The council have refused our certificate because they know full well it would undermine and usurp a policy block. This does not require planning permission. It's not development because it's not a material change of use under the provisions of the Town and Country Planning Act. We know we're right on this, and so we've presented evidence to the inspector, and we expect them to turn around and say, this is a creche. Because it's a creche, it's Class E, and therefore it can go to offices without any further impediment from the local planning authority. There we go. That's 21 years in a nutshell for you. If you're interested in the stuff we do. Those are my contact details. I have left enough time, I hope, for a couple of questions, which I encourage you to whack into the chat box. So please go ahead and do so. But otherwise, thank you very much. I'll stop sharing and see what you guys want to say in the chat. So there are a couple of questions. And let me just pop my video on because it's always nice for you to be able to see me as well. So James asks, how did you prove vacancy in the end, given they were paying business rates and it looked like they were still occupying? Good question there, James. What we had to do was provide photographic evidence from the purchaser's solicitor and the estate agent from 3 months prior, because it had been on the market for a while. It was vacant when the estate agent took it over. So we had to provide a statement from the estate agent and photographic evidence demonstrating vacancy. Once we'd done that, it was very difficult for the council to then turn around and say, we still think it's occupied, because ultimately it wasn't. And we were able to prove 3 months prior with photographs and other particulars published at the time that it was absolutely vacant. I hope that answers your question, James. If there's anything else, then please do not hesitate to pop it in the chat. Otherwise, we will leave it there. No. Okay, fine. Well, we will leave it there then. I hope that's been interesting. We plan to do a few of these over the course of the year, so keep an eye out for us on social media. We'll put bits and pieces inside our mailing list as well, and if you're on the Victory Plan Facebook group, then they might appear inside of that as well. Wonderful. James, what are the rules regarding what the councils can article for? Very well defined, James, inside of the NPPF and practice guidance. Now, they have to be the smallest possible area and they have to be well justified. And the Secretary of State is calling most of them in now. So governed by the Secretary of State there, James. Good. Any new class of serviced accommodation? Likely in England to go to sui generis. That's what Rishi Sunak says. In Wales, it is C5. Commiserations on 21 years. I'm pretty sure that's a commiserations there, Simon. Thank you very much. Right, good. We will leave it there. I hope that was enjoyable for everyone, and I will see you all very, very soon. Keep an eye out for the next one. Thank you very much.